the kind of experience where sir has practically seen everything and all things possible, things which can go wrong and simultaneously things which can go right. And yet sir has come out with shining colors and with bright and illustrious career in front of him. Sir has dealt with various MNCs such as Accenture, Motorola, and Huawei. And Sir's law offices have been set up primarily to provide high quality services with a quick turnaround and an affordable price. Sir has a degree in economics and LLB from Delhi University, and Sir has also studied at the Northwestern University School of Law, and where he completed his LLM. This LLM he completed with a concentration in international trade and financial laws. Sir also has an extensive experience of having worked on complex contractual transactions. The law offices of Vijay Tangri, which is the legal office of Sir, is specializing in offering corporate advisory and litigation services. This office also provides services to assist everybody with their contracting needs, such as drafting, vetting, review of contracts, review of contracts such as share purchase agreements, NDAs, bank guarantees, etc., etc. So essentially, it's a full service law firm that Sir heads, and like I said, this is the best kind of experience that even we at the beginning of our careers can get. Thank you so much for being a part of this session, sir. And we look forward to having a great learning experience today. Thank you so much.
Thank you. Thank you for the very impressive introduction. I hope I can live up to the expectations you would have raised with the introduction. Now, leaders of organizations like to focus on their core competency, which is growing the business, enhancing reputation and goodwill of the company. They have to instead, however, from time to time, indulge in firefighting surprises that come up along the way. Now, is it possible to avoid these surprises? The answer is yes, and I'll show you how. All we need to do is remember some very small things at various stages of a deal. For example, at the time of negotiation and signing of a contract for a deal, we need to very carefully review provisions relating to ownership of work products, acceptance criteria and payments, delay and contributory delay and the consequences of such delays. We also need to very carefully monitor and document the baselining process, which involves deciding on the periods during which performance will be measured and also what the performance will be benchmarked against. We also need to work carefully to identify and specify the minimum and expected SLAs and the limitation of liability. We can, at the very outset, put in place mechanisms to avoid any surprises by including clauses in the contract which put a cap on the ability of client to withhold disputed payments. We need to clearly and comprehensively identify and describe the dependencies and relief mechanisms. We also need to have clauses which provide us an opportunity to cure any breaches that may have happened on our part. What we need to do to avoid surprises further is that we need to educate our delivery teams on understanding the specifics of scope, the specifics of consideration of the contract, and train them how to identify communications that need to be responded formally. We also need to make sure that key subcontracts are entered into. And as working capital is key to the health of a project, we need to make sure that all outstandings are attended to and missing invoices are raised. We also need to make sure that the contract deliverables and milestones are identified and put into a formal document at the start of the project and are monitored and implemented throughout the deal period. We also need to ensure that all risks are identified at the beginning of the deal and monitored very closely during the life of the deal. We also need to make sure that commercial levers are identified and implemented. Very often, when the delivery is in process, we offer employment contracts to various individuals. These contracts need to be reviewed and drafted very carefully, keeping in mind especially the provisions relating to scope of work, salary, perks, termination, breach of contract, consequences thereof. We also need to have a separate agreement about confidentiality called the non-disclosure agreement signed by the employees. Very often, we have to spend considerable amounts on training our resources, as a result of which we want them to stay with us for a long period of time. For this, very often we get employment bonds signed by the employees, and this is effective only if they are reviewed and drafted carefully in line with the prevailing law at that time. Otherwise, they may not be effective if required to be enforced. We also need to identify and document our obligations in regard to business continuity and disaster recovery. We need to, at the bare minimum, have the following documentation in place, such as the business impact analysis, the business continuity strategy, and the business continuity plan. Also, when we are dealing with data coming in from the European Union, special considerations need to be adopted and taken into place into the project. For example, the EU data controls, EU data transfer agreements need to be implemented. We also need to implement restrictions on processing of personal data and implement the EU Parliament directives, and clauses adopted by the European Commission need to be signed. It is very critical for us to understand what we can do or not do under a contract, and this understanding needs to be passed on to our delivery teams as well, so that they know when there is a scope creep and they initiate the process of a change request before taking on the extra work. We also need to be aware of the amber and red countries and restrictions regarding them. That will help us avoid a lot of surprises. The legal personnel is very closely linked with the account leadership, delivery, PMO, and the CFM. This integration needs to be enhanced and encouraged. There are certain indications by which we can understand that there is a problem on the project. For example, the client stops attending major meetings. The client stops making commitments. For example, unsigned change orders are on the back burner for long periods. Then the deliverables being given over to the client are not accepted promptly. Client does not fulfill its dependencies. And if we can take into consideration these events, we will be very alert and we will be preempting any surprises. In conclusion, what I would like to say is involve legal early. Problems will not go away by themselves. Legal involvement will only lead to a better outcome. Thank you very much. Any questions? Thank you.
So for any of the questions that you may have, we would request you to kindly note them down and share the same with Advocate Tangri. Sir's contact details will be put in the description section, and please feel free to reach out to Sir specifically via email, and I'm sure Sir will be happy to address any of your concerns. I think that brings us to the end of today's session. Thank you so much, everybody, for joining us. I hope you had a great experience. And I'm sure these takeaways will definitely help you mold your career and ensure that all of the deadlines that are being put across for you to meet, you are able to deliver on time perfectly each time. Thank you so much for joining us once again today. Thank you so much, Advocate Tangri, for taking this session today and sharing your immense knowledge and experience with us. Sure, this will definitely help all our viewers out today. Thanks a lot again for taking the time out and doing this session today. Thank you so much, everybody. And I would also like to thank Lawyer for having organized this session today.
Thank you. Are we done, Ashwin?